Thank you very much, Mr. Speaker. Oh, a new day has dawned right here in the city of Castries, led by a government with foresight. Mr. Speaker, I sit in my little space as the member to my right normally says. And I must say, I want to commend those persons who put their thoughts together to at least bring a sense of expedition to the dispensation of justice in this country. Mr. Speaker, whilst the Attorney General was basically disseminating the information from which this bill unfolded, it dawned on me that one time, Mr. Speaker, there was a guy called Charles Pistache. He was arrested for murder, Mr. Speaker. And I walked to court on no less than 20 occasions. I was not his legal representative, but I walked to court on about 20 occasions and saw him there at the BS of the court. And all the prosecution said was, "Your Worship, we are not ready to proceed." And he was further incarcerated. Not even to mention, Mr. Speaker, the times when I probably was absent when the similar treat applied. One day, my mother always taught me, Mr. Speaker, check for the less fortunate. He had not paid me 1 penny, and I stood on my feet for about 2 hours, and I walked out with Charles Pistache. Because the whole synopsis was, there was an urge to arrest and then investigate, which means the cart was placed before the horse. And it was on that basis I was able to have the accused discharged. You see, I say all of this, Mr. Speaker, to tell you of the hurdles that our legal system, the hurdles that our system is inundated with, that prevents expeditious hearings and leave persons in prison incarcerated. Lord Denin once said, remand is a fanciful name for imprisonment. So whether you're on remand or you penal, you're in jail, and that's the harsh reality. You're in jail. And so, Mr. Speaker, sometimes the longevity that it takes to dispense justice, that in itself is an injustice. So I welcome this bill, Mr. Speaker. What the Attorney General should have told us, what is happening here, Mr. Speaker, is a replication of exactly what obtains in the magistrate's court. A magistrate is an arbiter of fact and make pronouncements on law. Sadly, in the High Court, the judge is the arbiter of law and the jury would be arbiter of facts. Now, Mr. Speaker, look at how obscene, if you want to call it that, a scenario can be. Let's say lastly, you steal $5,000, $4,500, they say it's a summary matter. So a magistrate can hear you by him or herself. But you top it up to $5,500, $1,000 more. And then they'll tell you it's an indictable matter, triable by judge and jury. You need to have police officers going on motorcycles looking for jurors left, right, and center. Some of them, they don't want to come to court because they fear ramifications of their presence in a criminal trial. Then you have bench warrants issued for jurors who don't turn up. So basically the ramifications and all of the rigmarole attached to judge and jury trial, Mr. Speaker, is what has caused us to be extremely dilatory in the dispensation of justice. So I really welcome the amendment to the code. I welcome, Mr. Speaker, everything that is in there, especially the fact that the judge would be arbiter of both fact and law, which is what obtains currently in magistrates' court. So there is absolutely no difference. You charge under the Firearm Act, and they tell you based on the caliber, it's a high court matter or indictable matter as it is legally referred to. So it's an indictable matter, but if it's a caliber or two lower, it's a summary matter. I don't understand why such a fundamental difference in going through a trial for the very object or transgression, because the item is just a little more powerful than the other. So I welcome that. One of the things I did not see in that act, though, Mr. Speaker, and I speak from a standpoint of being a defense lawyer for a very long time, and I dare say a very successful one at that. Mr. Speaker, what the criminal code had made provision for was pre-trial negotiations. And I can tell you, any party to proceedings in criminal proceedings would prefer the expeditious dispensation of the matter if a balance can be struck. So that you call the prosecutor, defense counsel goes with the magistrate, and you say, look, it was this, it was that, what is your likely sentence? Without necessarily clouding the mind of the arbiter. And then you could say, okay, my client, I wouldn't give, if we go down that road, he'll get 3 months rather than a year. You go back to your client, and that can be done and arranged. So that is the only loophole, Mr. Speaker, that personally I would encourage to be incorporated in this amendment, so as to facilitate an even more expeditious dispensation of the matters, of criminal matters in our jurisdiction. But I support the amendment to the criminal code. Thank you, Mr. Speaker.